Good morning, all students. I am giving a legal English dictation at the speed of 120 word per minute for the post of APS, private secretary and stenographers. Please ready 5 seconds. Start. Under subsection 3, subject to the superintendence of the academic council, the admissions committee is competent to lay down the principles of norms governing the policy of admission to various courses of studies in the university, and also to nominate a person or a subcommittee as the admitting committee in respect of any course of study in an institute or a constituent college maintained by the university full stop. Under subsection 4, the committee is competent to issue directions as respects criteria or method of admission, including the number of students to be admitted to constituent colleges maintained by the state government and affiliated or associated colleges. Of course, these directions cannot be in conflict with the government order issued under subsection 5 para change. In view of subsection 5 of section 28, pre-medical test has to be held in accordance with the directions issued by the state government full stop. The examination is to be held by the university nominated by the state government full stop. The university or the committee constituted under the government order can adopt any fair procedure for holding the examination, but it cannot evolve a procedure which is in conflict with the government order issued under subsection 5 full stop. If there is no conflict between an order issued by the committee constituted under the government order and the government order, the order of the committee will not be illegal full stop. In the present case, the norms dated 14/10/1990 were evolved by a committee nominated by the chairman of the committee constituted under the government order for combined pre-medical test 1990 full stop. In the rejoinder affidavit, constitution of this committee is assailed on the ground that it comprises officials of the Lucknow University full stop. That, in my opinion, is no ground to assail the constitution of the committee full stop. The government order lays down the broad principles on which the test has to be held full stop. Further norms have been laid down by the committee constituted under the government order full stop. The norms dated 14/10/1990 do not come in conflict with either government order or the norms adopted by the said committee full stop. I am therefore of the opinion that the norms dated 14/10/1990 are not illegal para change. The question now surviving for consideration is whether the said norms could be applied to an examination which had already been held full stop. The authorities cited by the learned counsel do not afford much guidance as they relate to the alteration of eligibility qualifications full stop. In respect of such qualifications, the law laid down, of course, is that the selection will have to be held on the basis of advertised qualifications full stop. In the present case, the eligibility qualification has not been altered and the norms evolved on 14/10/1990 have been uniformly applied full stop. It may be that if the norm relating to erosion had been evolved earlier to the examination and the examinees had been informed, they would have been more careful in answering the questions full stop. I am not inclined to interfere with the declaration of result, as all the candidates have suffered from the same disability from which the petitioner has suffered, and there has been no violation of Article 14 of the Constitution full stop. The fact remains that the earlier answer given by the petitioner was incorrect full stop. The number of such incorrect answers is substantial full stop. The petitioners has not suffered any prejudice which others have not suffered. Full stop. It will therefore cause hardship at this stage to require the university authorities to reevaluate the answer books, ignoring the norms evolved on 14/10/1990 para change. The matter raised in the writ petition pertains exclusively to academic field, and academicians are better equipped to evolve norms of the nature evolved on 14/10/1990. Full stop. These norms do not come in conflict with any statutory norm. Full stop. In the field of education, the courts must allow the academicians full play, and the courts may interfere only when there is violation of statutory provisions, constitutional provisions, and principles of natural justice. Full stop. In the present case, there is no violation of any of the three laws para change. In view of the above, the petition is dismissed, but without any order as to cast para change. Petition dismissed.